Hi, it's Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I'd like to talk a little bit about if it's okay to actually change your will by handwriting notes on your will. But before I get started, let me remind you that if you ever have any questions about a Northwest Indiana estate planning or probate matter, you can always reach out to me and set up an appointment at indianaestatemeeting.com. We can go over your concerns, your goals, and any issues that you have, and hopefully formulate a plan so that your life will be smooth while you're living, and any distribution of your stuff at the time that you pass away will be smooth, and your family won't fight with each other. So there you have it. So this was the issue that came up, and this is what I'd like to talk about. So somebody came up to me and said, hey, some of my family members, things happen in the family, and so they went ahead in their will and they scratched out this person, and they whited out this, and they did something else to the will. And we want to know if that is going to be valid, or after these folks pass away, whether there's going to be a problem with the will and whether somebody can go ahead and challenge the will. So the question is there's two questions there that we need to answer. The first question is it okay to have a handwritten will? Or in this case, a handwritten change to the will, which would be a codicil. And the answer is yes. You can have a handwritten will, and in Indiana, we recognize handwritten wills. So the second issue becomes, is it okay to just white things out and initial them, or scratch things out and change distribution or person's names or things along those lines? And the answer to that question is no. So the way that it has to be done, if you're going to handwrite a codicil or a change to your will, you have to meet all the formalities that you would have in a normal will signing. And that would mean you have to show, and people would have to attest to the fact that you were in your right mind, that you were over 18 years old, that nobody coerced you into actually signing the codicil, things along those lines. And then these folks would have to attest, the two witnesses would have to attest that you did it, it was part of your free will, you knew what you were doing, and all the other parts that are required under any Indiana statute for the signing or attestation of a will. So if that was done, if you grabbed two neighbors and the two neighbors came over and you wrote out, on this day, I, so-and-so, being of sound mind and body, am going to change this part of my will. Article 1, I want to name a new personal representative. This personal representative is going to be child ABC. And then I want to change my distribution. I want child A, B, and C to get distribution, something to the effect 40% to A, 40% to C, and 20% to B. And then you sign that and you date that, and the folks that are witnessing sign it and date it, and they attest that you were of sound mind and body, that nobody forced you to do it, and that all was good. You did this on your own volition. You knew what you were doing. You understood what you were doing. And then you are good to go. So you could go ahead and handwrite it. So there you have it. If you ever have any questions, you could always reach out to me. I am Guy DiMartino. Have yourself a great day.